No, that's all right. Okay, all right. No? Yeah, we begin? Yeah. Okay, so we may begin with Mr., all right. Okay, the Rules Committee will come to order. You know, recently, when I introduced the new artwork in the committee room here, specifically this piece to my left, I spoke about the hope that America embodies and the value that immigrants have brought to our country for generations. That's a belief of mine. And the principle that our diversity is our strength, the idea that our country is strengthened by immigration, these are core values of this entire majority, too. You know, when I think of the best of the United States, I think of the Statue of Liberty, which welcomes immigrants who come to this country. I think of my great-grandparents who came here without a penny in search of a better life for their kids and their grandkids. I think of a hopeful, confident country that's big enough and strong enough to welcome people of different races, religions, and backgrounds, knowing that they make us stronger, not weaker. What I don't think of is a cruel and ineffective Muslim ban. That makes us smaller. That diminishes us. That undermines the values that we claim to care about. You know, the President signed his first executive order on this issue 3 years ago on Holocaust Remembrance Day of all days. His actions shut the door to thousands of refugees fleeing war, including innocent women, children, and families desperate to escape violence. It was never about national security. Our nation already had one of the strongest vetting systems anywhere in the world. It was about the President trying to fulfill offensive campaign promises and further his harmful, hate-filled rhetoric about Muslims. It's now another election year, and according to reports, the President is looking at expanding the Muslim ban even further. Religious discrimination has no place in our nation's immigration decisions, period. That's why we are considering measures today that will terminate the President's Muslim ban and prevent him from issuing another one. At the same time, we are ensuring that individuals at ports of entry can seek legal advice during the screening process. In addition, we are also considering a War Powers resolution today, led by Senator Kaine, that would require a vote in Congress before the President escalates hostilities with Iran. It passed the Senate with bipartisan support, and I hope it can pass the House the same way as well. We need to get this to the President's desk so that Congress can start to reassert its constitutional authority over possible hostilities in Iran should tensions escalate. This President's foreign policy is reckless, it's chaotic, and I believe it makes us less safe. Some of my colleagues may choose to stand by him on this, but this majority is going to stand up to defend American values. With that, I'm now happy to turn to our distinguished ranking member, Mr. Cole, for any remarks he wishes to make.
Thank you very much, Mr. Chairman. I think I'll probably begin by applauding the Rules Committee for coming together during last week's hearing on Article 1 authority. I particularly want to thank you for that hearing. I thought it was very substantive. Discussion was not only, again, substantive and productive, but it demonstrated that what we can accomplish when we reach across the aisle and work together. After the bipartisan strides taken last week, it's very disappointing that the majority is back to deploying deeply partisan tactics this week that deny the minority its rights on the floor. There are two issues in front of us, Mr. Chairman. There's obviously an issue of substance, which you addressed very eloquently, but there's also an issue of process here. And let's look what's happening this week. Rather than bringing up the underlying judiciary bills on their own to stand before the House on the merits, the majority is instead using the gimmick of further amending a Senate-amended bill to package these items together. This has the effect of removing the minority's right to offer a motion to recommit on the bill before final passage. Since under House rules, the minority is not allowed to offer an MTR on any House measures that have been amended by the Senate. Mr. Chairman, you know as well as I do that the motion to recommit is the minority's traditional right that has been part of the House rules since the very beginning of the institution. But Democrats have been all too willing to limit this tool to silence minority voices, both Republican and even Democrat, something Republicans in the majority never did. We recognize the importance of the right to the chamber. This is now the second time in 6 weeks the majority is explicitly adopting a procedure to deny the minority its traditional rights. I think that if the majority is really so frightened of the motion to recommit that they really want to do away with it, then that change to the standing rules of the House needs to happen in the open on the House floor so that everyone can see how this majority operates. Their sly tactics today certainly accomplish their goal for the underlying legislation, but it does so in an underhanded way, and frankly, that's unacceptable. There's an easy solution to losing motions to recommit. Write better legislation that includes both parties and more views instead of undertaking legislative gymnastics to silence the minority. I understand that my Democratic colleagues are frustrated that Republican policies are getting enacted, but we're simply putting forth alternative ideas consistent with the rules of the House, ideas that a majority of the House agrees are the right positions. Instead of trying to convince your members that you're right, you're going to just rig the entire system to shut out not only us, but even them. We all know why. You cannot effectively defend your policies against competing ideas. And let's be clear on why this is happening now. Because we won another motion to recommit last week, our 6th in this Congress. It's happening because we committed the great sin of passing an amendment that would prevent sex offenders and terrorists from being employed by the TSA. That's really the policy that's causing you to strip our rights away. My friends on the other side and I disagree on a great many issues, but I cannot imagine how our amendment last week, which was really drawn from one of their members, could be one of those reasons. To now have the very same members that joined us last week to propose ways to protect the institution now be the members that are aiding in its destruction is shocking, and it's disappointing. I implore the chairman to reverse course and to continue defending the House of Representatives and the rights afforded to its members. I yield back, Mr. Chairman.
Thank you very much. The gentleman yields back. I'd like to welcome our witnesses to provide testimony on the No Ban Act and the Access to Counsel Act. We're happy to welcome Chairman Nadler and Mr. Jordan. You're delighted that you're here. Anything that you brought in writing will, without objection, be entered into the record. I'm now happy to recognize the gentleman from New York, Chairman Nadler.
Thank you, Mr. Chairman. Mr. Chairman, H.R. 2214, the National Origin-Based Anti-Discrimination for Non-Immigrants Act, or the No Ban Act, and H.R. 5581, the Access to Counsel Act of 2020, are two critical bills that together will stop executive overreach, defend Congress's role in establishing our nation's immigration laws, and right one of the original sins of the Trump administration, the obviously disgusting, immoral, and un-American Muslim ban. Last September, the Judiciary Committee and the House Foreign Affairs Committee held a hearing to explore not only the obviously disgusting ban, but also the chaos that unfolded at airports across the country when it was first announced, and the harmful effects of the ban, which continue today. I can personally attest to that chaos based on my experience at JFK Airport on the very first day the ban was implemented. In addition to the intended victims of the ban, refugees, individuals with valid visas and even lawful permanent residents were detained by CBP and were prevented from speaking with attorneys. Some even had their phones taken away and were unable to call their family members. So a disgusting policy was incompetently executed to make it apply to American permanent residents as well. Although that initial version of the ban was blocked in federal court, the Supreme Court ultimately upheld the third version, Proclamation 9645. Under Section 212F of the Immigration and Nationalization Act, the President is authorized to, quote, suspend the entry of all aliens or any class of aliens, unquote, when the President finds that the entry of such aliens would be detrimental to the interests of the United States. That authority was established by Congress in 1952 to ensure that the President can act swiftly to exclude narrow categories of individuals when it would serve the national interest. Until January 9, 2017, presidents of both parties honored this vision by invoking Section 212F in targeted situations to exclude small, well-defined groups of individuals from entering the country. However, President Trump has invoked this authority to usurp the will of Congress, to act in blatant disregard of the separation of powers, and to deliver on his immoral campaign promise to ban Muslims from the United States. For example, the President relied on Section 212F to render individuals who cross the southern border between ports of entry ineligible for asylum, ignoring the fact that our laws expressly provide asylum eligibility to any individual who arrives in the United States, whether or not as a designated port of arrival. The courts have consistently and appropriately held that while Section 212F grants the President power to respond to emergent situations implicating national security, it does not allow him to rewrite laws with which he might disagree. Or at least the courts did so until the aberrant decision by the Supreme Court, breaking with all common sense and precedent, upheld the third version of the Muslim ban. The separation of powers doctrine is enshrined in our Constitution and is sacred to our democratic society, and we must do everything we can to protect it. Congress writes the law, the President enforces the law, period. As members of Congress, we should all agree that no President, Republican, Democratic, or otherwise, should be permitted to use Section 212F to override legislative mandates and to implement religious persecution. These are the kinds of abuses that the No Ban Act will stop by amending Section 212F to ensure that not even the current Supreme Court can misconstrue it. And it is critical that we move quickly, even given the frequency with which this administration invokes Section 212F to eliminate policies that are unlawful and shock the conscience. H.R. 55, and that is why we are combining these two Senate bills, because it will enable the Senate to act more quickly than otherwise in order to stop the unconstitutional and disgusting policies as quickly as possible. H.R. 5581, the Access to Counsel Act of 2020, would address a long-standing issue that grabbed the headlines in the immediate aftermath of the first Muslim ban: the lack of access to outside assistance for individuals who are subjected to prolonged inspection by the U.S. Customs and Border Protection. Due to the complexity of U.S. immigration law and the fact-intensive nature of questions regarding admissibility, it is not uncommon for some people to languish in secondary inspection for hours. During this time, they are often cut off from the world. Some even have their phones confiscated. And if the individual is lucky enough to have a lawyer, CBP will often refuse to speak with that lawyer, even if they can provide critical information or correct a legal error. Our immigration laws are very complex, and grave consequences can result from being refused admission, consequences that extend well beyond simply turning around and getting back on a bus or plane. For example, an individual is given an expedited removal order, is barred from returning to the United States for 5 years. And imagine the harm that is done to such an individual when there was no proper basis for issuing an expedited removal, but he couldn't fight it because he couldn't have access to the lawyer who was standing across the hall. H.R. 5581 allows applicants for admission to the United States, including U.S. citizens, to communicate with counsel and other parties if they are subjected to secondary inspection that lasts longer than 1 hour. To be clear, this bill unfortunately, does not provide a right to counsel, nor does it impose any obligation on the federal government to pay for or otherwise provide counsel to individuals during CPP inspection proceedings, but it does provide the rudiments of due process. It does ensure that American citizens who are wrongly identified or permanent residents who are wrongly identified have an opportunity, if they have a lawyer there, to speak to their lawyer to straighten it out and not be subject to the complete caprice and error of the local inspector. The Congressional Budget Office found that H.R. 5581 would have no effect on direct spending or revenues. Moreover, the inclusion of language from the Affordable Prescription for Patients Act of 2020, which would increase access to cheaper generic prescription drugs, results in a net positive CBO score for H.R. 2214. In conclusion, I'd like to extend a special thanks to my colleagues, Representatives Chu and Jayapal, for their leadership on these issues and for introducing these important bills. I encourage my colleagues to support them and to support them as rapidly as possible as they head to the House floor.
Thank you very much. Mr. Jordan, welcome.
Thank you, Mr. Chair. And thank you for having me and the ranking member as well. I'm here because Ranking Member Collins cannot be in, and so I got his statement that I'll read for the committee. The majority is playing procedural games. They know that 2 bills that they want to move are expensive. According to CBO, the No Ban Act will increase direct spending by $290 million over the next 10 years and increase deficits by $307 million over the same time period. And a preliminary estimate from CBO notes that the Access to Counsel bill will increase discretionary spending by at least $1 billion over the next 5 years. So the majority had to come up with a pay-for. They opted for this prescription drug legislation, but chose to discard bipartisan, committee-passed text to include a flawed prescriptions bill that will stifle investment in research, prevent new medications from coming to market, block truthful advertising, and disincentivize improvements to patient care. This Congress has unanimously passed 6 bipartisan bills out of committee to address the cost of prescription drugs. But today, instead of using bipartisan negotiated text, the Democrats have made prescription drugs a partisan issue in an effort to pass partisan immigration legislation. Our president has taken several decisive actions to help ensure the safety and security of our country. Every time he does so, my Democrat colleagues cry foul, attempt to block the president's action, and threaten to take away his power. And the president's January executive order updating travel restrictions for nationals from several countries is no different. The Department of Homeland Security has identified several types of information that it needs in order to make a reliable decision regarding the admissibility of a foreign country's nationals seeking entry to the United States. This includes things like, does the country report lost or stolen identity documents, including passports, to Interpol, and how often do they do so? Does the country share information about their known or suspected terrorists or about their criminals with us? And does the country issue modern electronic passports? These are important things to know when determining whether to let a foreign national into our country. They're not disgusting, as my colleague just said. They're common sense. Instead of expressing appreciation for what this president has been able to accomplish with regard to security, my colleagues have decided to consider the No Ban Act, which effectively eviscerates the ability of the administration to take quick and decisive action to protect our homeland when concerns arise, even action to prevent entry of aliens based on a global health crisis like the coronavirus. Till the president signed the first travel executive order in January of 2017, very few had ever heard of Immigration and Nationalities Act Section 212F authority. This provision provides the president broad latitude to impose restrictions on the entry of aliens or classes of aliens to the United States when such entry, quote, would be detrimental to the entry of the United States, end quote. And it has been used successfully by Presidents Reagan, President Obama, and others. Was President Obama acting disgustingly, I might add, when he used this same authority? Pursuant to the travel and executive order, the president required Secretary of DHS, Secretary of State, along with the Director of National Intelligence, to determine what countries fail to meet international standards of information sharing or identity management, or when at a high risk of terrorism or public safety concern, and to report their findings to him. Based on that assessment and the recommendations of the secretaries, the president placed travel restrictions on 7 countries pursuant to the continued review of countries and an updated report. In January, the president issued a proclamation imposing narrowly tailored travel restrictions on 6 additional countries. It's important to understand that such restrictions are not permanent. When a country comes into compliance with the information sharing and other requirements, they can be removed from the list of restricted countries. That happened for Chad in 2018, and press reports have already noted that the government of Nigeria is working to come into compliance. There's no doubt that this president's use of 212F authority has helped improve our security and the vetting of foreign nationals seeking entry to the U.S. As DHS Assistant Secretary for Threat Prevention and Security Policy testified last September, 1 country reinstituted a dormant program to help identify convicted criminals. 3 countries have adopted more secure e-passports. 2 countries obtained access to Interpol databases for the first time, and 8 countries began reporting lost and stolen passports to Interpol for the first time, or improved the regularity of that reporting, close quote. These are not insignificant improvements to the world's security. H.R. 2214 would take 212F authority from the president and give it to a subordinate. Under this bill, only the Secretary of State can determine that the entry of aliens is a threat to the U.S. This is problematic in instances where other cabinet officials should be involved, such as HHS or Treasury. H.R. 2214 also contains onerous reporting requirements, consultation with Congress before a president can act, the Federal Register publication of information about the action taken, and the circumstances necessitating the action in the first place. Of course, it makes no sense for the U.S. government to broadcast to the public the deficiencies they have identified, since those would then be exploited by bad actors seeking to harm those foreign countries or perhaps the United States. The most ridiculous part of this bill's provisions is Section 4, which not only terminates the travel executive orders in place, but incredibly ceases, quote, all actions taken pursuant to any proclamation or executive order terminated. This means that the information sharing on terrorists, criminals, and other security threats that is derived between the U.S. and other countries with travel restrictions would stop. And the majority has also decided to consider the Access to Counsel Act. This bill is a way for the majority to test how far they can go right now toward their ultimate goal of taxpayer-funded counsel at every stage of the process of immigration. The bill mandates that the DHS Secretary shall ensure that an individual who has been selected by Customs and Border Protection for secondary screening at a port of entry has a meaningful opportunity to consult with counsel and an interested party, close quote, during such screening. Secondary inspection is used at ports of entry to give CBP officials time for additional screening that may take longer than the normal case. It can include more in-depth questioning, additional databases, searches, and physical searches when an individual is suspected of carrying contraband on his person or in his car, truck, or baggage. Secondary inspection is done in an area near the primary inspection booths and serves to remove those whose admissibility may be in question from the primary inspection line so as not to slow it down. The vast majority of people admitted in the United States do not get referred for secondary inspection, but annually, over 17 million do. Allowing 17 million people to consult with counsel or some other, quote, interested party will bring legitimate trade and travel to a grinding halt. These bills would undermine the safety and security of Americans, and I would urge this committee to adopt a rule allowing for meaningful amendments and debate. And with that, Mr. Chairman, I yield back.
Well, thank you very much. I appreciate your testimony. I'm not sure if I heard you correctly, Mr. Jordan. I think you referred to the coronavirus, that somehow this bill would frustrate the president's ability to be able to effectively, prevent people from coming here who may have the coronavirus or some other issue. And I just wanted to say for the record that there is a clarification in the bill on page 7, which says that the term public safety includes efforts necessary to contain a communicable disease of public health significance. So I think it's pretty clear that the president has the authority to do what he must to protect our country in the face of coronavirus or other communicable diseases. So in any event, look, I think both of you were clear in your positions. I was clear in my position in the beginning. And so I would now turn this over to Mr. Cole for any questions or comments he may have.
Thank you very much, Mr. Chairman. Mr. Chairman, I'd like to begin by asking unanimous consent to insert the Statement of Administrative Policy on H.R. 2486 into the record, which states that were this bill to become law, the President's advisors would recommend he veto it.
Without objection.
Thank you very much. As I made clear, Mr. Chairman, many of my objections are really process-related, and they really are. I mean, I think it's, we probably disagree on the underlying issue here, but to bring this forward in a way that blocks our ability to influence and really meaningfully participate in debate, I think is really, a very sad thing for this body, and one that I'm sorry to see we've seen increasing use of in recent weeks. And I would just urge my friends to rethink that. It's not a way to build bipartisan consensus, particularly when you have a position I know you believe in very strongly and hold in a very principled way. I know you're more than capable of standing up in any debate anywhere, anytime, and defending what you believe. Every other member should be willing to do the same thing. Chairman Nadler, I do have a couple of substantive concerns, or at least questions. Are you concerned in this case by the general use of 212F authority or the specific use of 212 authority by the president? In other words, you have a general problem with any president doing this, or is this specific?
No, I do not have, I think I made clear in my statement, I do not have a problem with 212F generally. It's narrowly drafted. It's a narrowed grant of power to the president. I think we've done a lot of grants of power to the president we shouldn't have, but this is not one of them. But I do think that this president has grossly misused it in a way that is, as I said, disgusting and immoral, but beyond that, contemptuous of the powers of Congress, that he's overreached, and that we have to stop him both substantively and to make sure that that no president can misuse this kind of power. It's a grant of a narrow power, and he's used it very broadly, wrongly, but also very broadly. And the bill is designed to deal with both of those problems.
Okay, and then to be just crystal clear, and I know your answer here, but I want to get it on the record. This legislation, obviously, as my good friend the chairman said, does not terminate Presidential Proclamation 9984, the COVID-19 China travel, or the February 29th proclamation related to Iran travel. Is that because you view them as appropriate uses of 212F authority?
I'm not sure of whether, well, certainly of the correctness of the policy in those cases, but it's clear, in my opinion, that they're within the President's prerogative and properly so.
Okay, thank you very much, Mr. Chairman. Ranking Member Jordan, if H.R. 2214 was law, what would be the process to use 212F authority to respond to COVID-19? I mean, it's part of our problem here. We're sort of inserting ourselves into very tightly defining what a president can do.
Yeah, I think it would make it longer, more burdensome, and potentially more costly, because it's just going to add layers to the authority that the president has. That is our concern. It's why we should have amendments, I think, on the floor and get a chance to maybe clear some of that up. But I think it's going to make a process much more burdensome and potentially detrimental to the country.
Well, I want to associate myself with the ranking member's comment. Again, this is a big power we're talking about. There's no question the president has the power.
Yep.
And no question that my friends who might disagree with his use in one area actually probably agree with it in another area. And that gets you into a pretty knotty issue. And I think my friend from Ohio makes a good suggestion, Mr. Chairman, when he says, we're going to have this debate, let's have it openly, let's have an open rule on it, and let's have a very thorough discussion. Otherwise, I think we're sort of running the risk here of overreaching ourselves and interfering with President's legitimate powers. With that, Mr. Chairman, I yield back.
Thank you. Ms. Torres? No question. Mr. Woodall? No. Mr. Perlmutter? Dr. Burgess? Dr. Burgess?
Yeah, thank you. Mr. Jordan, you referenced in your testimony the Section 212F of the Immigration and Nationality Act. You know, the president had never served in public office before. And he has utilized a tool that was in the Immigration and Nationality Act, just as he used a tool, the Section 301 tariffs, to help normalize our trade relations with China, and he used the emergency declaration from 1977. These are all statutes that were passed some time ago, and the president has found those to be tools in his toolbox, and he is using them. Where Mr. Nadler say he would not want to do away with Section 212F, but I mean, if Congress doesn't like what the president does, Congress can change the laws, right? We still make the laws.
Yep.
It's just an observation. Again, you marvel at the fact to hear someone who's never served a day in public service until he ascended to the highest office in the land. I think his instincts are absolutely aligned with the American people, and he's done the right things.
I would just add to the gentleman's comments. My guess is the president thinks that's why he was elected. I mean, that's why the people put him in office, is to do some of the very things that you referenced and that he has clearly the authority to do.
Thank you, Mr. Chairman. I'll yield back.
Thank you. Mr. Raskin?
Thank you very much. Chairman Nadler, is there anything in this legislation that would prevent the U.S. government from keeping people out of the country who present a public health threat if they were to enter the country?
Certainly not. The legislation is recognizes two things. Number one, it recognizes, in the opinion of the authors, that the use of this power in this case was terrible and well beyond the powers granted by Congress. It also recognizes that the power that Congress granted is a necessary power but must not be minimized, as I think the members of the minority up here have said. And it, insofar as possible, ensures that a future president, or the current one, will not abuse the statute. And all it says, really, is that the administration must, or the president invoking the power, must certify the public safety threat to the United States and the nature of it, for which he's using the power. the suspension must be narrowly tailored to that purpose, which is, as you know, cognizable as an issue in court. If the power is used in a way that's narrowly tailored to its purpose, then it would pass muster. If it's not, a court would have authority to abrogate it. But this is, again, just trying to assure compliance with the current statute by a future president. It mandates an assessment and recommendation by the Secretary every 15 days or so as to whether the suspension, as to whether the condition, the emergency still applies and goes on. So it does what it can to limit the president to a proper use of his current power. It can't dictate it, unfortunately.
Yeah.
But that's what it does.
This whole thing started, to my recollection, in the first few weeks of the Trump administration when the president issued his original notorious Muslim ban order on travel from 7 different majority Muslim countries. And I think actually during the campaign, he had actually floated quite explicitly the idea of banning Muslims until we could figure out what's going on and rhetoric like that. Earlier in this year, he expanded the travel ban to include 6 more countries. And this is causing devastating consequences in the lives of all of our constituents. I assume if your districts are in any sense similar to mine, but I get constant inquiries from constituents. I just thought I would bring one of them to give people a sense of what's going on because of these indiscriminate categorical bans on people from certain countries. So dear Congressman Raskin, happy holidays. I got this during the Christmas time last year. I could really use your help. I know there are so many pressing issues which demand your attention, and your constituents appreciate your hard work, but my family and I need you. We are suffering needlessly under the travel ban, aka family ban. I'm a natural-born U.S. citizen. My husband is Syrian. I've known him since 2011. We've lived in Istanbul since 2015. We're married in 2016. And have completed the CR1 visa, conditional green card for spouse, process in its entirety, including his visa interview, which took place August 31st. We had 0 issues, and we were told by the consular officer that our case was perfect. But now we are in administrative limbo. I miss my family back home. I have my husband here, but we're both isolated because we're foreigners without any family and very few friends. We'd like to start a family of our own, but we've been waiting because I don't want to raise my children in Turkey, and I don't want to raise them in America without their father. It's also my wish for my mother to meet her son-in-law of more than 2 years. She's getting older, and I'm constantly worried because I'm so far away, and I want desperately to spend time with her and my family. Finally, as you can imagine, it can be very stressful and disheartening living in a constant state of uncertainty, feeling insignificant and forgotten. I've developed motor tics due to this stress, which is both mentally and physically painful and overwhelming. I just want to come home, but not without my husband. I don't know why I'm forced to choose between the two. I don't know if there's a way to press the waiver issue, but I'm sure you're aware of the Yemeni woman who is trying to reunite with her dying 2-year-old son. Congresswoman Lee's Twitter said, thanks to public outcry and our work behind the scenes, the State Department has granted Shaima Shwele a travel ban waiver. Obviously, this family situation is more dire than ours, and I'm so relieved she was able to see her son. That being said, maybe someone can fight for me. If marriage is a civil right, how can this administration ban my spouse indefinitely under the false pretense of national security and a sham waiver process that Justice Breyer described quite accurately as mere window dressing? I would really appreciate it if someone could contact me about this issue. Thank you much in advance. And so we've been fighting for this person. We've been fighting for lots and lots of people in the exact same situation. So is this the kind of situation that the legislation is designed to address?
Very, very much so. We have any number of such situations. The very first day that the travel ban was imposed, back in January of 2017, I rushed to the airport, and Congresswoman Velasquez too, and among the people who were suddenly being denied entry to the United States and trying to send them back were Iraqi citizens who had risked their lives to help the American troops as translators and so forth, were under death threat back home, and had managed through our embassy, and after great efforts of about 2 or 3 years, had been perfectly vetted and so forth, and they were heroes. They'd saved American lives, and their lives were direct threat because of that, and they were being sent back.
And there's been a dramatic reduction in the ability of the interpreters and translators and assistants from
Right.
Iraq to get into the country, and the same thing in Afghanistan.
The basic problem with this application of Section 212F is that it's based on fear, religious prejudice, and generalization. Now, if the president had some basis for saying so-and-so from Syria or so-and-so from Iran is a threat to the country, by all means.
But that was always the law, wasn't
That was
it?
always the law. But the fact of listing countries which may or may not have good vetting things, and we know that some of the countries that were put on the list did not have good vetting procedures. Some did. Some that had bad vetting procedures then got good vetting procedures. It didn't matter. All people, whether they'd helped American troops, whether they posed a threat or not, were banned just because of a prejudice against that country. So anybody in a country like Iraq or wherever in combat should have his head examined if he helps us, because he puts himself in danger and we won't help him.
Well, and that's another way of saying that is that it undermines our ability to get the assistance that our troops need.
It undermines our national security in that way, certainly without question. And it's a basic product of prejudice. We don't like Muslims. We can't say that, so we'll say we don't like people from Syria or this country, but the list bears no relationship to anything other than the predominantly Muslim countries. I've heard defenses of the list that not all Muslim countries are on it, thank God, but they're doing their best. But in any event, it's totally irrational. It's totally irrational. If we want to protect people, the United States, and we should against people who pose a threat, figure out who poses a threat and protect us.
Do you have
a
the
blanket ban that hurts people who are victims or who are blameless or who help us?
Chairman Adler, do you have the list of the countries that are presently part of
Not with me.
of the ban?
Not with me.
Do you have it, Mr. Jordan?
I think
We'll have
Burma.
it in a moment.
Okay. I guess my question is, I know that at least at certain points, there are, is Afghanistan currently on the list? It is not. Is Iraq currently on it? It is not, okay. Because
Let the record reflect the back row shaking their head.
I'm sorry. It's not the list, okay. I guess that I would just close with this point. Everybody should read their mail, and everybody should read their email and get the calls from constituents, because our constituents have family who are in these countries. Our constituents have spouses who are in these countries. There are people in these countries who have helped the U.S. government. There are people in those countries who want to come over to see members of their families for weddings, at funerals, for high school graduations, for college graduations. Why would we just indiscriminately and arbitrarily write off the ability of people from certain countries to come into America? As the chairman of the Judiciary Committee tells us, if somebody is a public health threat, then by all means keep them out as a public health threat. You could be a public health threat from any country all over the world. In the places where the coronavirus started, we don't have a travel ban, right? And we shouldn't. We should have the ability to keep out specific people. If someone's a national security threat from any country, they should be kept out. But the idea of stigmatizing and typecasting and scapegoating people from certain countries just hurts us. It hurts our communities and our families. And it strikes me as completely antithetical to all of the major values of our Constitution. We have here the idea of religious freedom and free exercise of religion. We have here the idea of equal protection. We have the idea here of no taint of blood, which is in our Constitution. We have the idea here of rejecting under due process mass guilt and collective punishment. This is not what America is about. So I very strongly support this legislation, and I just want to thank the Judiciary Committee for bringing it forward. Mr. Nadler, please.
Let me say there is unfortunately precedent in American history for this. The same kind of prejudice and stupidity produced the Chinese Exclusion Act of 1882, which said all Chinese people are threats to the United States and can't come here. It was followed up by other acts banning all Asians. 1924 Immigration Act was passed specifically to keep out Jews and Italians, because Jews and Italians were obviously threats to national security, and that was stated on the floor of the House and the Senate. It took us 40 years to get rid of that law. This is the same thing. It's prejudice here against groups, irrational and un-American prejudice, in those cases against Chinese and Japanese and Jews and Italians and Irish earlier, everybody. Same thing here, this time against Muslims with a thinly veiled excuse.
I yield back, Mr. Chairman. Thank you.
Ms. Lesko.
Thank you, Mr. Chairman. First of all, I just want to make a statement. The constant use of this as a Muslim ban is totally false. I mean, if it really was a Muslim ban, as you guys say it is, why wouldn't he have banned Indonesia, which is 99% Muslim? I mean, this makes no sense to me at all. And also, all these adjectives that are used by Chairman Nadler over and over and over again, the rhetoric, I don't think helps the cause either. But I do have a question for Mr. Nadler. Chairman Nadler, you stated just before that the president appropriately used 212F authority for the coronavirus response, but did not, oh, you didn't say that?
No.
Okay.
I said he's used it many times appropriately.
So do you think then that it is appropriate under 212F for the COVID-19 response?
Let me, no, I don't, because it's irrational and doesn't help public health. If we want an intelligent public health response to coronavirus, to COVID-19, you have to do it on the basis of risk. And the basis of risk is what all our doctors and scientists tell us. It is not on the basis of who's on a specific cruise ship, or I forget the other criteria the president used, but they were just totally wrong. You have to, and you don't need Section 212F, by the way. You have plenty of other laws to do this. But the fact of the matter is, you ought to prevent people who are public health risk from coming here, but you have to do it rationally in accordance with scientific principles. And I don't remember the details of what the president proposed, but they're completely wrong. And I should say, nothing in this bill is relevant to that question in any event. There's nothing, this bill has nothing to do with coronavirus. If the president is using his authority under Section 212F or anything else appropriately for public health, this bill wouldn't affect it. If he's using it inappropriately, there are plenty of laws that stop him from doing it now. It's just a different subject.
Well, and so to follow up on that, Chairman Nadler, my staff passed me a question and said, well, if you don't think that it's appropriate for the president to use this in the case of COVID-19, why didn't you explicitly take that out of the bill then?
Well, it is appropriate if this law and many others, I can't name them all, but the president has ample authority to protect the country against public health threats. He does not have authority to use prejudice or in determining who's a public health threat. And all this bill does is say essentially, I mean, remember, the 212F gives the president the power to exclude people on the basis of threats to the United States, public health or otherwise. All this bill does is try to limit that power to be more rational by saying he's got to list his reasons. There's got to be specific and credible facts, which could be judged in court. There's got to be an assessment every so often by HHS, which can be assessed in court. It tries to keep a president more narrowly focused. It tries better to enforce existing laws, the best way of putting it. And so to answer the question, is it appropriate to use the authority to prevent coronavirus? Sure, like any other thing. But the proposals the president is making so far have nothing to do with that. He talks about coronavirus, but they go in the opposite direction.
Well, we respectfully, I disagree. I think it's important for public health if, let's say all of Italy is locking itself down to think about these type of things. I don't think it's irrational, in my opinion.
Certainly not
I think it's rational.
Certainly not inappropriate or irrational to think about them. We're not saying that. And the law doesn't, the bill doesn't change that. It continues to allow the president to use his authority to protect from threats to public health. The restrictions on any president remain. All this does is say that the president has to be a little more explicit in why he's doing it in a given instance, so that the courts have a better way of enforcing the law.
Thank you, and I yield back.
Ms. Scanlon.
Yes, I just wanted to clarify a couple things about H.R. 5581, the Access to Counsel Act. This relates to work that I did before coming to Congress, where I certainly had occasion to help obtain representation free of charge to the government for folks who were seeking entry into the U.S. or who were in deportation proceedings. And we've established through testimony at many of our hearings in the last year that without counsel, the chance of someone being able to exercise rights that Congress has given is greatly diminished. And it just seems so contrary to the rule of law and the values that our country is founded upon that the government could be able to deny someone their rights simply by not letting them know what they are. And it's not just folks trying to get entry to our country from other countries. We established in hearings before judiciary that, in fact, American citizens have been deported and refused entry to our country because they lacked counsel. So I don't see how this bill can be in the slightest controversial. I do understand that there's some allegation that somehow it's going to cost the government money, but as I read the bill, it doesn't seem to say that the government has to provide counsel. It just has to allow those who have counsel available to them to talk to that counsel. Is that right?
You're quite right, unfortunately. It would have been much better if we were able to guarantee everyone due process, if we were able to guarantee that everyone subject to any kind of proceeding like this has a lawyer, but we didn't do that. All this bill does is say that if someone being held in detention for at least an hour has a lawyer, he's got to be able to talk to them. And this arose from the fact that on the first day of the Muslim ban, when Nydia, Congresswoman Velasquez and I were at the JFK airport, we had lawyers there who wanted to help their clients, who wanted to help people. Presumably some of them had good cases, some of them didn't, but they were refused access. The lawyer is standing here. The person who's trying to get into the country, who may have been an American citizen, who may have misclassified, who may have been a green card holder, who may not have been, is standing here. I'm standing in between them trying to let them talk, and the CBP is saying they can't talk. So all this bill does is say, if you have a lawyer and you're held for at least an hour, which means you may need a lawyer, then the lawyer has to be permitted to talk to you. But by what conception of due process do you say that someone who may be subject to severe penalty, being kicked out of the country, an American citizen being kicked out of the country because they screwed up his credentials or whatever, or somebody else, by what right do you say that anybody who's subjected to severe penalty may not talk to a lawyer who's standing there? I can't think of anything more un-American. This bill corrects that.
I would agree, and in fact, several of my former colleagues were in that situation of being at the airport, available to talk to people who were being denied entry and having access be denied. In fact, I believe our colleague, John Lewis, led a sit-in at the Atlanta airport when CBP was denying access to counsel to people who were being held there. So with that, I would yield back.
Thank you very much, Mr. Morelli. Ms. Shalala.
Mr. Chairman, under the Muslim ban, my grandparents would not have been allowed to enter this country. And I point that out because they were Christians. And what this Muslim ban has done, the unintended consequences, is actually restrict the number of Christians from those countries that can come into the United States. That is, as well as their Muslim neighbors. And my grandparents would be appalled that this ban was in place because of the opportunities they had to come to this country. There's no justification for it. It's absolutely racist. I do want to go back to the consul issue because my office has 500 immigration cases in which we have volunteer lawyers that are available. They're not being allowed even into the courthouses. They have to stand outside. Due process is not being offered to so many of these people, even when they have lawyers, even when they're paying lawyers, let alone the volunteer lawyers. And as we know, they're less likely to be able to get their cases fairly adjudicated if they don't have lawyers. So I am very much in favor of this bill. But also the unintended consequences. We shouldn't ban Muslims. We shouldn't ban Christians. We shouldn't be banning anyone from coming to this country because of their country of origin as opposed to their own personal characteristics.
Would the gentleman yield for a second? Will you just tell us what country were your grandparents from?
Syria at the time. It wasn't Lebanon at the time. It was Syria. And right now, if you're a Yazdi or if you're a Chaldean, I mean, the number of people that have been, that are Christians that have been persecuted in Syria, in 2018, it was 20 people that were allowed in this country.
Let me just answer. You're obviously correct, and we have a major problem that this bill does not, just goes a tiny bit toward addressing, which is the provision of due process to people in all sorts of situations. I believe that everyone in a courtroom or in any proceeding before some sort of government body needs a lawyer and should have one that should be paid for by the public if necessary. Unfortunately, this bill doesn't do that. But that's what we ought to do if we really care about due process. And you also give me the opportunity to remember Ms. Lesko's question that I forgot and didn't answer, and that is why we keep saying that this is a Muslim ban when allegedly it is not. And the answer is because the president told us so. The president, during the campaign, said we're going to ban all Muslims. And when he tried to, and he said so. He said, why, why? And he told us. And then when he became president, he tried to do it. And they had to fix it up so that it looked constitutional. They tried, and we had 3 in a row before the Supreme Court finally upheld one of them. But we know the effect. We know the intent. The president told us. We ought to call it what it is, what he told us it was, a Muslim ban.
You, generally, you'll back? Okay.
Mr. Chairman,
Mr. Woodall.
could I ask one question? I thought one of my colleagues would cover it. We've been talking about the immigration side, the pharmaceutical side of this bill. What was the reason when the Judiciary Committee, in rare form, passed out a completely unanimous prescription drug bill, 2375? What was the reason for keeping Title II of the Rules Committee print as the Senate language instead of using the bipartisan language that the committee?
I'm sorry, what was the reason, what?
The Title II, as I read the Affordable Prescriptions for Patients Act, looks a lot like H.R. 2375, which was a bipartisan bill,
Right.
but it's the Senate language in its entirety.
Oh, why do we substitute Senate language?
Instead of our bipartisan product.
For speed. We think it's very necessary to enact this legislation as fast as possible, and the Senate is ahead of us in the legislative process.
Though the committee's reported a bill, we just haven't moved it across the floor. So many of our bipartisan prescription drugs bills, we
I
don't.
agree. We reported
I know it.
2 bills, in fact. I've been trying as hard as I can to get our leadership to move the bills as fast as possible. I think we ought to do it. We ought to pass the bills. Senate's going faster, so give them the opportunity, period.
Mr. Jordan, is there any more to the story?
My understanding is the Senate Republicans were fine with the bipartisan legislation. I don't know why. I mean, Mr. Nadler said it's for speed, but I never have put speed and the United States Senate in the same sentence. So I don't know that that's the
Jordan
case.
is usually right.
Yeah, okay, well, so this is the first exception, but I think we could have went with a bipartisan prescription drug bill, and I wish we would have.
Well, given that given that we have a Rules Committee print, we're changing the language, we're sending back to the Senate brand-new language that they're going to have to deal with anyway, and they could just as easily have dealt with our bipartisan product. You know, so often when the Judiciary Committee comes up here, we're talking about things like the use of travel language, things that divide us.
Mr.
Here's
Woodall-
something that unites us.
Say, yes, we have bipartisan legislation in the House. The Senate legislation is also bipartisan. It's almost identical to the House bill. And frankly, we want to move whichever moves faster, and that appears to be the one that can move faster at the moment.
Well, we're sending it back to them. They're going to have to pass again whatever we send back,
I
whether we send them.
understand that, but we've reached a conclusion they can do it faster. If we can do it faster, we will.
You don't believe
It's the same bill.
you don't believe we've lost, nothing in our House, in
No.
our collective House wisdom has been left out of the Senate.
No,
of
they're
the Senate
essentially
language.
identical.
I thank the chairman, thank the ranking member. Thank you, Mr. Chairman.
Ms. Lesko.
Thank you, Mr. Chair. I just want to correct something I said earlier. Indonesia is 87% Muslim, not whatever I said. Thanks.
The record will reflect your correction. Any additional questions or comments? Seeing none, I want to thank our witnesses for being here. You're excused. And there are any other members who wish to testify? I see none. This closes the hearing on these measures. And without objection, the committee stands in recess, subject to the call of the chair.
Yes, so I hear.
back Chairman Nadler, and I know Mr. Jordan is here somewhere. I saw him.
Your mic?
Yes, to provide testimony in HR 6172, the USA Freedom Reauthorization Act of 2020. And Chairman Nadler and is Mr. Jordan, is he? Okay, yeah, we're delighted to have you here again. Anything you brought in writing will, without objection, be entered into the record. I'm now happy to recognize the gentleman from New York, Mr. Nadler.
Thank you. Thank you, Mr. Chairman. Mr. Chairman, when Congress enacted the Foreign Intelligence Surveillance Act, or FISA, in 1978, it did so to address a particular problem. Left unchecked, the executive branch is all too willing to unleash its considerable surveillance capabilities on the American people. President Nixon had spied on his political adversaries in the name of national security. We obviously needed certain surveillance authorities to help keep us safe from foreign threats, but we required those authorities to be better aligned with our values and our respect for privacy, civil liberties, and the rule of law. And so in the aftermath of Watergate, we acted to bring those wielding these authorities under the daily supervision of the court and the regular oversight of the Congress by enacting FISA, which established a secret court to deal with questions of foreign intelligence. Over the years, FISA has been expanded by the Patriot Act, among others, to include not just traditional surveillance, but also pen registers, trap and trace devices, the acquisition of business records, the interception of electronic communications, and other provisions. Now, to be clear, many members, myself included, have found some of these changes to be deeply destructive of our privacy and civil liberties. I oppose the original Patriot Act and many other changes to FISA over the years. But this work is an ongoing project. From time to time, we have been able to come together in a bipartisan fashion to rein in these authorities, to curb abuses, curb specific abuses, and to bring the law back in line with our values. I'm glad to say today we are again in concert bringing legislation to rein in some of these abuses in a bipartisan manner. In 2015, under the leadership of the gentleman from Wisconsin, Mr. Sensenbrenner, Congress adopted the bipartisan USA Freedom Act. That bill ended the NSA's bulk collection program and required the government to provide some measure of individualized suspicion before combing through our phone records. It provided for a court-appointed amicus to keep executive branch lawyers honest in cases involving new technologies and novel applications of the law. And remember, we're talking about a secret court where the public doesn't see what's going on. So we invented in that bill the public amicus to represent, in effect, not the executive branch. And it created a regime of greater transparency. If the Department of Justice wants to advance a novel legal theory to acquire certain information or to avoid certain disclosures, they may eventually prevail upon the FISA court, but now we will know about it when they do, we will read the court's opinion, and we can respond as necessary. That is all now starting in 2015 public. The USA Freedom Act also reauthorized 3 provisions of the law scheduled to sunset unless extended by Congress. First, the business records provision of FISA known as Section 215, which enables the FBI to obtain certain, quote, tangible things in the early stages of a national security investigation. I should add that I led the opposition to this provision back in 2001, but we did extend it with some limits in 2015. Second, the roving wiretap provision, which allows the government to track certain suspects across multiple devices. And third, the lone wolf provision, which permits surveillance in certain extreme circumstances where the government cannot establish a direct connection between a foreign terrorism suspect and a specific foreign power. To date, this provision has never been used. The USA Freedom Act extended these authorities through December of last year. Given a number of circumstances beyond our control, including the timing of a key report about the FBI's misuse of certain FISA authorities, we agreed to a brief reauthorization of these 3 provisions through March 15th so that we could better deal with them. That deadline is now upon us, and we must act. The bill before us today, H.R. 6172, the USA Freedom Reauthorization Act, improves upon its namesake and again brings several surveillance authorities back in line with our values. It is by no means a perfect bill. There are many changes to FISA that I would have liked to have seen included here, but we cannot let the perfect be the enemy of the good. This bill is an important package of reforms. First, this bill ends the Call Details Records program that began as part of a secret and unlawful surveillance project almost 20 years ago. Ends it. Over the past 4 years, we have permitted the NSA to collect certain types of phone records in a setting that requires individualized suspicion, court supervision, and full transparency with the committees of jurisdiction. Unfortunately, as we put those limitations on the previous authority. Unfortunately, this program proved technically difficult, wildly expensive, and of limited value to the intelligence community. The government shuttered the program voluntarily last year. This 2-decade experiment has run its course, and our responsibility is to bring it to its formal end. In a separate attempt to bring the business records provision in line with the law, this bill also prohibits the use of Section 215 to acquire information that would otherwise require a warrant in a law enforcement context. In recent years, our understanding of the Fourth Amendment has come to recognize a privacy interest in our physical location. The law may continue to develop to recognize privacy interests in our Internet searches, our biometric data, and other aspects of our daily lives. To the maximum extent possible, the public will get to see how that standard evolves. The bill requires the government to disclose all significant opinions of the FISA court within 180 days and makes explicit reference to the Fourth Amendment provision in that requirement. The bill also requires a one-time historical review of all significant opinions issued by the court since its inception, because they haven't been made public. The Department of Justice may have good cause to classify the details of any particular case, but there is no reason that important interpretations of the law should be secret any longer. Now, since we circulated the original draft of this bill, we have heard from a wide range of stakeholders, from the most progressive members of the Democratic caucus to the staunchest supporters of President Trump, and they have convinced us to make additional changes to the bill. To address the concerns of those who seek additional guarantees for privacy, we have made several changes. These include new retention limits, new reporting requirements, mandated reports to explain legal issues, and an explicit prohibition on the use of Section 215 to obtain GPS and cell site location information. Other members asked us to address the deep structural flaws in FISA identified by the DOJ Inspector General in the report issued late last year. We have done that. Working with our Republican colleagues, we have mandated additional transparency in FISA applications, created additional scrutiny for cases that involve elected officials, and elevated the consequences for misrepresenting information to the FISA court. And although I am certain that this bill is not a perfect vehicle, indeed, I think there's a lot to be desired that I'd like to be in the bill that isn't there yet, I will continue to press for additional reforms to FISA. I am proud of the agreement we have reached and the changes we will make to bring these authorities back in line with our values. I urge my colleagues to support this legislation. I yield back.
Thank you. Mr. Jordan.
Thank you, Mr. Chairman, Mr. Ranking Member. Let me start by saying, contrary to a couple hours ago, I agree with the chairman. I think this bill doesn't go far enough, but it does represent real reform. And I appreciate the work of the majority party along with a number of other interests that help put this together. This bill before us represents real reform to the FISA program. These reforms have long been necessary, but have been especially warranted in recent years, given the FBI's spying on the Trump campaign affiliate Carter Page and the affront to First Amendment rights that this represented. This bill makes explicit that an amicus should be assigned to cases involving political activities, amongst other kinds of cases. The amicus is limited to a 5-year term with the exception for good cause. There was no requirement in law to have another set of eyes double-check the FISA applications to make sure they were accurate and met probable cause before submitting it to a court. We authorize independent legal advisors to look for concerns and provide requirements for the approval of applications. Previously, there were no clear regulations that governed the accuracy of FISA applications. We now require in this legislation the Attorney General to promulgate rules to ensure that FISA applications are accurate and complete. In fact, the IG, the Inspector General, is now required to annually assess compliance with accuracy procedures. Same IG, this I think is important, the same IG who just 3 months ago, Mr. Horowitz, gave us the report that told us what took place back in 2016 and 2017, where the FBI went to the FISA court, misled the court 17 different times. 17 times. They didn't tell the court important things like the guy who wrote the dossier, Christopher Steele, was, quote, desperate to stop Trump. They didn't tell the court the guy who wrote the dossier, Christopher Steele, was being paid by the Clinton campaign. Now that's the kind of thing that I think these reforms begin to address. The Carter Page application was full of omissions and errors. Applications now have to reveal any information Any information that calls into question or raises doubts about its accuracy, getting to the very point I just made that took place just a few years ago relative to a presidential campaign. The FBI did not disclose to the court that it had neglected to employ even basic investigative techniques before applying for a FISA application for Mr. Page. We now require the FBI to describe what investigative techniques it carried out before making the application. The Page investigation did not require the sign-off of the Attorney General. I think this is important. We now require the Attorney General to approve in writing any FISA investigation of elected official or federal candidate. We think when you're talking about the First Amendment, you're talking about political activity, it makes sense for the Attorney General himself or herself to actually be invested in this and sign off on the front end. FBI lawyers involved in the Page application engaged in misconduct and weren't punished. Now someone who knowingly hides information from the court shall face appropriate adverse actions, including, as appropriate, suspension without pay or removal. There was little accountability for those who lied to the court. This bill makes it a crime, punishable by contempt, to willfully make a false statement to the FISC, to the FISA court. There was little accountability for those who, without authorization, disclosed information in a FISA application. If you leak information, this bill increases maximum imprisonment from 5 to 8 years for the intentional, unauthorized disclosure of FISA applications. We don't know what was said at the court hearing, if there even was a court hearing, or what communication the Department of Justice had with the court about Mr. Page's application. The court now has to transcribe hearings, and the intelligence committees in both the House and Senate maintain their right now to receive applications, orders, and relevant materials in a timely manner. And finally, there was no one person in the FBI who had the responsibility to make sure the Carter Page application was accurate. This bill establishes the Compliance Office and the position of a compliance officer for the FBI who shall report to the FBI director and is specifically charged with ensuring the accuracy of the application. In short, as the chairman said, there's no call detail records anymore. That's a huge win. The amicus process kicks in for anything relative to First Amendment concerns. There are penalties for giving false information to the court. There are penalties for hiding information from the court, and there are penalties for leaking information about the application to the court. The Attorney General has to sign off, as I just talked about, when we're talking about First Amendment political activity, and there are transcripts now made of the proceedings that the intelligence committees in the respective houses of Congress will get a chance to see. And that in and of itself, the idea that someone is now going to be able to look at what took place, is a check on what I think took place a few years ago that was so darn wrong. And of course, there, as the chairman mentioned, there is the prohibition on GPS and cell site location information, which we think is an important privacy victory, important victory for liberty. So that's what's in the bill. Again, we wanted more, just like the chairman did, more on the civil liberty side of things. But this is definitely, I think the chairman would agree strongly, but this is definitely better than where we are with current law. And that's why we're here talking about this legislation. With that, I yield back to the chairman.
Yeah, I wanted more. But anybody have any questions? Mr. Cole.
Just a quick comment, Mr. Chairman, if I may. I just want to thank both of you, quite frankly. I think the toughest thing in government is this appropriate balance between individual liberty and the defense of the Republic and the American people. And, I'm probably more of a defense hawk. I'm probably more in the civil libertarian camp. This is a really good effort, a bipartisan effort to find common ground. I just really want to thank you, Chairman, and you, ranking member, for working together. I know there were a lot of people on both sides that had a lot to do with this. I know that made the management, Chairman, I'm sure, difficult from time to time. But when we can see a major agreement come up here from people that ideologically in other areas, usually have different points of view, it just makes me feel good about the institution, about the people in it, about the effort to find common ground and work together. So I thank both of you for what you've done. It may not be perfect in anybody's sight, but I have a lot of confidence that people on both sides said, this is a step in the right direction, and we can move this forward. And thank each of you for what you did to make that possible.
Well, thank you for those comments, and I want to take the opportunity to thank Mr. Jordan, the ranking member, for holding our feet to the fire when he had to, and for his efforts and for making this a better bill.
Well, while we're, if I could, Mr. Chairman, just while we're thanking folks, I do want to thank the staff. They had a day last week where staff were working from noon until about 9 o'clock at night on Thursday. That continued on Friday. They met over the weekend. They met all day yesterday and today. Both the chairman's staff, Mr. Collins' staff who worked for the Oversight Committee and soon for the Judiciary Committee, and Mr. Nunes' staff, along with folks from the White House. So I actually kind of think that's how it's supposed to work from time to time around this place to get something done. So I want to commend all the staff who put in just a ton of hours of work on this.
And let me not be remiss by saying the same thing. The Democratic staff worked incredibly hard on this. We're very original and creative in coming up with solutions that people could agree on from who were at loggerheads, and worked extremely hard. I want to thank the entire Democratic staff and the Republican staff too, because we saw them work hard also.
Okay. Anybody else? Mr. Torres?
Why are they special provisions that deal with special treatment for members of Congress or people holding federal office or a candidate to a federal office? Why is that?
Because that's what prompted this. And when you're talking about the FBI specifically targeting a presidential campaign, my guess is that's probably not happened in American history. And so I think the thinking was, if you're going to surveil a elected official or a candidate for office, that should be something that the Attorney General themselves, himself or herself, actually has to sign the dotted line. Not the Deputy Attorney General, not the Director of the FBI, but the head of the Justice Department themselves. So the thinking was that just one more kind of check when we're talking about something so fundamental to the First Amendment, your right to speak in a political fashion, which was definitely abridged, as evidenced not by what Republican congressmen are saying, but by what the Inspector General gave in his report, or detailed in his report just 3 months ago.
You're talking about,
Norma.
can I just clarify, you're talking about a candidate for office. I was a former candidate for local office. I was a former candidate for state office. Now I'm a candidate for a federal office. It is my understanding that this special carve-out deals with members of Congress. Is that true?
Potentially, deals with elected officials.
I am not sure why we think we're special.
We're not.
I'm not sure why we
We're
would
not. This
think
needs to
we would
be-
write something that would hold us to a different standard, that we would hold our constituents in our district. We're not above the law. That is, I mean, we have to get that right,
Can I answer that?
please.
Of course, we're not above the law or any different than anybody else. This originated from the FBI investigation of Carter Page, et cetera. As the Inspector General reported, there was an abuse. It was directed against elected officials. But the answer is that you want to limit surveillance as much as possible. You want to make sure that surveillance is only used in the most necessary circumstances. You want to protect everybody. One way of doing that, beyond every other way we've figured out in the bill, is to require the Attorney General to personally sign off. We could have written that the Attorney General must sign off on every application, on everything, but that would be physically impossible. We had to limit it in some way, and it was felt that the potentially most damaging invasions by an administration.
I'm sorry, Mr. Chairman. I'm incredibly disappointed that we are talking about the Attorney General. We're talking about the same Attorney General who is now on record as being the attorney, the personal attorney for this president, not for the American people. So in this bill, do we also have penalties? Should the Attorney General leak information to a potential suspect?
Yes,
And can you talk about that? Because that makes a big difference
No,
for
I
me.
just said it goes from 5 to 8 years if you leak information about a fight.
Well, that's for anyone else. It's not
Anyway,
specific to
including
the
the attorney.
Attorney
No,
General.
including, that's for all. That's for all. I want to treat everyone the same, but this was driven out of what prompted the whole thing, which was what the FBI under the Obama administration did when they specifically targeted a presidential campaign. And again, we know that happened because Mr. Horowitz issues a report. We had an FBI individual falsify an email so they could get the application to the FISA
I'm
court and get
sorry,
the
we
warrant to
also
spy.
had an Attorney General that provided a 3-page memo that it was inconsistent to the FBI.
It was not
George,
investigation.
if I may answer
Yeah,
that,
no,
because
just make sure one person talks at a
Okay.
time, because our
Let me
stenographer
answer
can't
that.
keep up with it.
I fully agree with you that Mr. Barr is not to be trusted. He will not be the Attorney General forever. We must write legislation for, regardless of who the Attorney General is. I disagree with Mr. Jordan that during the Obama administration, an investigation was undertaken for political reasons. This has been debated forever with us on one side and the Republicans on the other. It's clearly not true. It is true that, and this legislation doesn't deal with that. But it is true that in the course of investigating that, we found certain abuses. The Inspector General reported abuses, which were made against Carter Page in this case, but could have been made against anybody. They were not directed by the administration or anybody else, but they were directed by low-level FBI people. But it is important to write legislation to try to prevent that further, to try to tighten that up. Now, and that's what we're doing. The reason for saying against elected officials is because the most damaging potential is if surveillance powers are improperly used against elected officials or candidates. It's bad enough against anybody else, but the worst thing is to interfere in the political process. And since we had to limit it somehow physically, that was the only way we could limit it. Now, we've provided many provisions in the bill to limit those kinds of abuses generally. This one, we couldn't generalize beyond that, but the worst case is whether it's Barr going, whether it's some FBI official that we found, going again in the Carter Page investigation, or whether it's a Barr deliberately distorting the Mueller report or calling on improper spying, which he may have done or may do in the future. We're trying to put a limit on power, regardless of how directed, because we have to protect civil liberties. So it's not a question here of giving, and for this provision, because you can't require the Attorney General to sign off personally on every single thing, because that would be physically impossible. We had to come up with some limiting factor, and the limiting factor is what's the most dangerous. The most dangerous conceivable is when you're using this to interfere with a political campaign, to target a political candidate, to target Obama, to target whoever, and that we required the personal sign-off to further limit that possibility. And yes, the Attorney General may be a total dishonest person, as our current one is, but hopefully we'll have, in the future, better Attorneys General. And I must also add that, yes, you have pointed out real problems with the Attorney General. We are developing other legislation to try to rein that in, but that's not this bill.
Thank you. Anybody else have any questions? Mr. Woodall.
Thank you, Mr. Chairman. I just want, thinking about how we go the extra mile to explain this to folks back home because of the civil liberties implications. To say we're doing something today that makes it a crime to lie to the court, to withhold from the court, and to leak from the court. Every single one of my constituents would say, what have you guys been doing since 1978? Haven't those things always been wrong? Can you talk a little bit about, I don't know if it's a culture change in terms of who's presenting before the court, if we're just particularly panicked about it. We used to expect that from the Code of Ethics at the Justice Department, but now we're going to make it a statutory requirement. The whole story I've been telling about FISA courts is that folks who present there have an obligation, a different obligation to tell the whole story, the exculpatory side of the story, a different obligation than what you would ordinarily see in an adversarial
Very,
position.
very quickly, they do indeed. That obligation has been there. It has been breached repeatedly, and everything we're doing essentially is trying to figure out ways of making it harder to breach it and to figure out in advance how to have better protections against someone who would breach it, and better reporting requirements as part of that protection, and also bigger penalties, basically, is
Yeah.
the whole approach.
Contempt is new, and the penalty goes from 5 years to 8 years. So, and then there's the, as the chairman mentioned, there's the stuff on the front end, that the process and protocols that are going to be in place statutorily that the FBI and the Justice Department need to do on the front end before they go to the court, to make sure the application they're putting together, they're not lying in the application as they did a few years ago relative to Carter Page. So that's how you want it to work, is you want a clean, accurate application before it gets to the court. But if they still screw it up, and if they do it knowingly, there are going to be real penalties. And the other thing that I think is so important to understand is the idea that the HPSI, that the committees are going to get the transcript, now all of a sudden they got to think at some point someone's going to see this. Not 3 or 4 years later, as was the case with the Carter Page application, but much sooner after it's happened. And that is a check in and of itself, which I think may be one of the best elements of the legislation.
I know we'll see an amendment from Mr. Davidson later that would require a public disclosure of folks who have been disciplined under these procedures. Is that a threat to the FISA process in any way? I'm thinking about your comments, Mr. Chairman, where you said this has these responsibilities have been breached repeatedly.
The answer is, I don't know. I might have to study that. The responsibilities have been breached repeatedly. That's why we tightened it up in 2015. That's why we're tightening it up now as much as we can. We have to, however, have certain secrecy. That's why we have a FISA court in the first place. So your question, which I just forgot, was...
Public disclosure of who's been disciplined.
We'd have to take a close look at that as to whether that would breach. I suspect, it sounds like a good idea, but we'd have to take a close look at whether, for some reason, the intelligence community can persuade us that that would be very damaging to national security.
I think...
It wouldn't think so, but we'd have to take a look at that.
I thank you both.
I think it's a great idea, by the way.
Any other questions? Dr. Burgess.
Thank you, Mr. Chairman, and thanks both for our witnesses for being here. So with the new parameters that you've put in place, I'll just confess to having some of the same anxieties we've heard from the other side of the dais, but mine are obviously from a different perspective. If we roll the tape back 3.5 years, all of these safeguards are in place. I don't know that I'm comfortable that Eric Holder and the director of the FBI, Comey, would not have still done the things they did if the intent was to get this guy. All of the errors that occurred to the detriment of Carter Page. I mean, what are the chances of that happening? I get it, people can make mistakes, people are human, but they all went in one direction. Now,
The only answer is, we can't guarantee human behavior, obviously. We can't write a statute that says thou shalt be nice, or thou shalt obey the law. All we can do is tighten up everything we can think of tightening up to make it harder for people to do what we don't want them to do, to make it more likely that they will be discovered in time to prevent them from doing it, and put heavier penalties. And that's essentially what we're doing. In other words, I can't guarantee that that FBI agent would not have lied, but under this bill, we'll have much more likelihood to know about it and be able to prevent it. And he'll have a much greater penalty, and it'll be public, so that you can even, without an IG report, you'll periodically see what's going on.
so I guess the question I have, is anybody going to be held accountable for what happened?
For what already happened, they have to be held accountable under law. This bill cannot affect.
Correct, but there still was a 5-year penalty for, I mean, I don't know, I'm not a judge, but I got to believe if you lie to a federal judge, that's a big deal. And someone lied to a federal judge repeatedly.
Well, I assume he'll be prosecuted for perjury. He should be.
Well, why hasn't that happened?
I don't know. Maybe.
Well, you're the Judiciary Committee. Have you asked the question? I mean, where's the oversight of this process?
The Justice Department doesn't as a matter of policy and their right, they don't tell you who they're investigating. They will not, perfect example, in the summer of 2016, there was a lot of reason to believe that candidate Trump was under investigation. Had that been revealed, it would have been highly embarrassing to him, whether he did anything wrong or not. I asked the FBI at a hearing in September of 2016, we keep hearing that Trump is under investigation, is he? And they refused to answer the question, and rightly so. So just as they couldn't answer whether Trump is under investigation, they can't answer, or then they can't answer whether Carter Page is. They have to, and I can ask the question, but I shouldn't get an answer. They have to make a prosecutorial decision. Yes, we're going to indict him, and then that gets announced. Or no, we're not going to indict him, that gets announced.
But if there were missteps along the way to get to that process by the people who were supposed to be overseeing the process, where's the check and balance on that?
There are a lot of checks and balances, and the whole purpose of this bill is to put in more checks and balances. Everything we've talked about is more checks and balances.
Yeah, but is anybody going to be accountable now for what happened? I mean, things went wrong, things were done wrong.
If the gentleman.
Yes, sir.
Yeah, this is exactly what the Attorney General has tasked U.S. Attorney from Connecticut, John Durham, to look into. And his report is investigation and is report. If there's a report, his investigation is due to be completed sometime this summer. He's looking at that very question. We know from Mr. Horowitz's report that there was an FBI lawyer who altered an email, directly changed the meaning from not reliable source to a reliable source. So 180 degrees changed the meaning of that email, and that was used to buttress the application taken to the court to get the warrant to spy on a fellow American citizen. That happened. So I got to believe that individual at some point is going to be held accountable. The chairman did say something earlier that is exactly wrong. He talked about low-level people at the FBI were responsible for this. That is completely false. Completely false. They took this investigation, went from the field office, they brought it to a headquarters special. This was Jim Comey, Andy McCabe, Jim Baker, Peter Strzok, and Lisa Page, top people at the FBI. We're talking about the director, the deputy director, the chief counsel, Jim Baker, and then FBI counsel, Lisa Page, and deputy head of counterintelligence, Peter Strzok. They ran the investigation. That is not low-level people at the FBI. That's why we need these additional checks and balances that are in this legislation. That's who did it. And when the Attorney General testified for the first time in a public hearing in front of Congress last spring, it's why he said there was a failure of leadership where? Upper echelon of the FBI. So it's not low-level people at all. It was the top people who did this. That is why you have to, if we just would go with a clean reauthorization, that would be so dangerous to the country. That is why you have to have some reform, and this is a good start. It's not far enough. I don't think it's far enough, but it is a good start. And that's why we're supporting it. I think it's probably the best kind of agreement we can get when you got the makeup of our government, split government right now. And that's why we're doing it, because it was not low-level people. These were the top people in the Justice Department of the previous administration. That's why this is so darn important.
Sure, yeah, go ahead.
I control the time, but I'm happy to recognize the chairman.
Thank you. Let me just, a factual matter. I will point out the disagreement here. It's not worth debating. We'll be debating it forever in public. We have been already. The Inspector General report found that certain low-level people did certain wrong things, gave certain wrong information, committed certain crimes, and they ought to be prosecuted. And the purpose of the bill is to tighten that up so that can't happen again, et cetera. The IG did not find that all these top people at the FBI were part of it. They said that they did a perfectly fine predicate investigation, but they were low-level people who misbehaved. That's a political. Excuse me. You said your version.
lied 3 times.
Well, that's not what
It's in the Inspector General's report.
Can I make a
all
suggestion?
I want to say is that's a political debate. It doesn't bear on, which we will have, I'm sure, ad nauseum. Doesn't bear on this bill. On this bill, Mr. Jordan is quite correct. We are doing things in this bill to correct any of those things that we saw or can think of, and we're in agreement on those things. And there's no point debating what did happen. We can debate it in the political realm, but not over this bill.
But all the errors that were made to the detriment of Carter Page. Can you think of a single error that went in his favor?
I am not defending the people who did the wrong things to him at all.
Well, what assurance do any of the rest of us have that we couldn't be in the same damn position
Well,
tomorrow night?
that is why we're doing the bill to put in these protections. Every time you find that someone is able to find some loophole to do bad things, you try to correct it. No one denies that that Carter Page was wronged, and no one denies that certain lower-level people did these things. There's a political debate about what went on top, but that's irrelevant to the bill. The bill corrects as far as we can determine all the conditions that enabled people to do that to Carter Page and a lot of other things.
That's the old, where do I go to get my reputation back? I mean, we've destroyed this man, and it's not right. I'll yield back.
Ms. Lesko.
Thank you, Mr. Chairman. I have a question for the chairman, just so I can clarify something, since I haven't read through this. My colleague, Representative Torres, was concerned that there was a part of this bill that just dealt with federal elected officials and candidates. Is that part just that the Attorney General himself has to sign off on it? That's all it is, right? There's no other carve-outs or anything like that, right?
No.
Okay, thank you.
It's just an extra protection so that, an extra protection against political interference with political candidates.
That's great. And I have to say that I'm pleasantly surprised that this got done, and we got reforms before the deadline, and I'm very pleased about it, and I want to thank both of you. Thank you.
Thank you. No other questions? Thank you very much. Oh, Mr. Perlmutter.
Do either of you have an objection if I amend the bill to add the Safe Banking Act, the marijuana and banking?
Doesn't go far enough.
Okay, thank you very much. I appreciate you being here. We have another panel, Mr. Gomer and Mr. Davidson. Please feel free to summarize your comments. Anything you have in writing, we can submit for the record. We go with you, Mr. Gomer. Make sure your microphone's on. Yeah. Do we have copies of your memo? We have it already. Yeah.
So long as you haven't sneezed on that, Louis.
Just make sure your mic is on. Is your microphone on?
Now it is.
Okay, good. Okay. Mr. Gomer, you're recognized.
All right. Thank you, Mr. Chairman, and I appreciate your time. And I appreciate the questions from both sides. Very thoughtful, all of them. Let me address a few things that have already been brought up. First, my amendment, it would exclude citizens of the United States from the FISA court. In that regard, I would direct your attention to FISA. It stands for Foreign Intelligence Surveillance Act. I was here before my dear friend Jim Jordan was when we were told about the Patriot Act reauthorization and what the FISA courts were doing. And we were told American citizens didn't have to worry unless they had contact with a known foreign terrorist or someone who was affiliated with a known terrorist group. Otherwise, American citizens, you were safe, which was a good thing because the Constitution, Article 4, says in order to get a warrant, that no warrant shall issue but upon probable cause supported by oath or affirmation and particularly describing the place to be searched and the persons or things to be seized. So we kind of put that aside for American citizens with the FISA court because you could go in and a lot of us didn't realize, and we got the WikiLeaks release of an application, affidavit, and warrant. I read those things, and I'm going, wait a minute. I've signed no telling how many warrants, but you have to have application, you have to have facts in the application, and they have to be set out in the affidavit establishing a probable cause that a crime was committed, that this person was involved in the crime, and then you have to describe with particularity the things to be searched and the things to be seized. That's supposed to be there. And what did the application, the affidavit, and warrant say? Basically, you know what? Verizon, we want everybody's record, everybody's phone records you got. And the affidavit said, yeah, we need everybody's phone records. This is obviously a summary. And then the warrant said, yeah, give them all the phone records. I'm going, holy cow, that's And I understand we can get into debates about pen records and what's has reasonable basis for privacy. But the thing is, the FISA courts for years have played fast and loose with American citizens. And I really appreciate the fact that Chairman Nadler and Ranking Member Jordan and others have been participating, but this should have come before the full Judiciary Committee. This is so serious. We should have had all of these things out. And you would have been amazed to see how many agreements on both sides of the aisle we could have had on some of these provisions. But just as was pointed out earlier, the penalties were already there for going before the FISA court and stating something false. They were already there. And they weren't used. And when we had Christopher Wray before our committee here recently, I was wanting to know, okay, you had an attorney that lied to the FISA court. He changed information from being true to untrue. And what happened? Well, he was just allowed to retire, resign, move on to a better civilian job. There were already penalties there. If there were 8 years instead of 5 years, that wouldn't have changed what happened to him. And I know there are people that dislike Attorney General Barr. It seems to me he's doing a good job, but that's one of the reasons it's so important that we agree on something that's this important when it comes to Americans' rights and constitutional rights, because there are different people that will be in, whether Republican or Democrat administration, and now President Trump is getting some of his folks in the Department of Justice. Some of us would say, thank goodness. Others on this side would say, not so. But that's why we need to be in agreement that we should be protective of Americans' rights. And so my amendment just takes out the ability to go after an American citizen. And I know there can be an argument, well, it shouldn't just protect citizens. What about people here illegally or legally? No, but the Constitution should be applied and has been, most cases, applied to American citizens. And so that's why immigration works the way it does. But American citizens should not be included in a secret court. And frankly, when this negotiation for reauthorization was being discussed, we shouldn't have had secret negotiations about the secret court and what could be agreed on to fix things, because it doesn't. And by the way, requiring the Attorney General to sign off, and I know we heard, well, he can't do it in every case, so that's why we put the provision in there just for federal politicians. Look, it ought to say American citizens, and Ms. Torres, you're exactly right. There shouldn't be any difference between us. If you're, in my opinion, American citizen, whether you're running for federal office or not, it's not enough to have an attorney general sign off on it, because the attorney general had recused himself. The acting attorney general even signed one of the applications. So he did sign off on at least one, maybe more, and certainly he would have had knowledge of all four of the warrants in question. So that's not enough. But that's why I say, if you want to go after an American citizen, the Constitution ought to apply, not the secret court. And I tell you, as a former felony judge, it offends me to no end that these FISA judges had people come commit a fraud on the court, and they went 2.5 years without ever saying, oops, that wasn't a very good thing. I mean, most judges, and most federal judges I know, who are not FISA judges, who are not in a secret court, they would have called the lawyers in and they would have reamed them, and somebody would have been paying fines and doing some jail time for fraud upon that court. And they hadn't done that. So I am totally uncomfortable that FISA courts protect American citizens. And let's make, this is a novel idea, why don't we make the Foreign Intelligence Surveillance Court apply to foreign intelligence and not American citizens? And some would say, well, no, it's too important, because what if they are engaged with foreign terrorists? Well, we had foreign spies before the 70s. We got through World War II, the Cold War, most of it, without the FISA courts. If it's an American citizen, you go to an Article III federal court. You don't have a secret star chamber. And I've had these before where there were national security secrets. You have an in-chambers hearing, but it's not a secret star chamber where there's just inadequate accountability. So if we're not going to get to amend this thing to actually put teeth, more teeth than is there, then I'd say for it, I beg you, at least let's take American citizens out. Democrats, Republicans, independents, socialists, they should not be subject to the FISA court. Let's make the FISA court not an American Intelligence Surveillance Act, but foreign.
Thank you.
That's my presentation.
Mr. Davidson.
Mr. Chairman, colleagues, thank you so much for your work here on the Rules Committee. Seems like a thankless job, so you should have plenty of job security here. Look, this is a passionate topic, so I've got two amendments. One is fairly incremental. It passed by voice last Congress. It's titled the Confess Your Transgressions Amendment. And I think it gets to the heart of what a lot of us feel, frankly, whether it's Debbie Lesko's district or Donna Shalala's or Mr. McGovern's, Mr. Cole's, mine, or yours. We probably get similar questions. When is someone going to jail? The reality is, as has been highlighted, there are already things that have been transgressed, whether they rise to the level of something that should be charged, prosecuted, or not. We really rarely learn of them. The Director of National Intelligence is already required to submit an annual report to the Intel Committee. My amendment wouldn't make that public. It would make it so that that report would contain disciplinary action. So it would say any disciplinary action taken against an employee of the United States government relating to mishandling information acquired under the Foreign Intelligence Surveillance Act. This amendment applies retroactively, and it includes foreign intelligence surveillance court-ordered requirements, administrative procedures for mishandling data. So again, it passed by voice last Congress in the House, and it did not survive its path through the Senate. It's a good amendment. It simply says what we all want to know is that somebody is actually being held accountable. And it could be that, you know, John Doe simply was on the job for 2 weeks and accessed the information inappropriately, and so he was given additional training. It could be that it was more malicious than that, and there was a disciplinary suspension. It could be that it was terminated. It could be it was reassigned. Or it could be that there's actually a criminal prosecution under the way. And the reality is, since there are humans in these agencies, we would be surprised to find that there was nobody that transgressed the law. The reality is that right now, CIA and NSA report when data is mishandled, but Congress has no idea what these organizations do to actually prevent their employees from abusing their power or positions of trust. Congress needs to make sure that federal agencies who use FISA are disciplining officials who abuse their power. So that's that amendment. Any questions about that one?
We just go through all of them, yeah.
Okay, so the next one is, because there's a lot of passion on this, and frankly, the committee process has been violated, and the proposal is that we go with a closed rule. We already saw that the original bill that Chairman Nadler intended to go to committee with had to be withdrawn. It's not clear that the rule will pass to me. I don't know how Democrats do it, but I've seen rules fail when Republicans were leading. And I know you all wouldn't want that to happen. So safe to say Republicans are probably already opposed to the bill. But, you know, Mrs. Torres highlights legitimate political concerns. You know, no one likes to see a bill that is the Politician Protection Act or something along those lines. And so because this gets to the heart of one of the vital things that we do as a country, the trade-offs between security and liberty, I've offered an amendment that would reauthorize the roving wiretaps provision, which is a concession. As our colleague, Mr. Gomer, highlight, the Fourth Amendment requires specificity and name a place and purpose for the search. And this basically says, no, we get it. People are using burner phones, changing it. We want to know that this is the target. We're just searching whatever this person may access. So it reauthorizes that for 3 years, but it lets, and the lone wolf provisions for 3 years, but it lets the 215 provision lapse. It could always be taken up again, but it would keep the essential element of the FISA court intact while we continue to do our duty and debate it. I guess I'd last like to read, for the benefit of application here, a brief poem by Mr. Frost, Robert Frost. 2 roads diverged in a yellow wood, and sorry I could not travel both and be one traveler. Long I stood and looked down one as far as I could to where it bent in the undergrowth. Then took the other, just as fair, and having perhaps the better claim, because it was grassy and wanted wear. Though as far as for that, the passing there had warned them really about the same. And both that morning equally lay, and leaves no step had trodden black. Oh, I kept the first for another day, yet knowing how way leads on to way, I doubted if I should ever come back. I shall be telling this with a sigh. Somewhere ages and ages hence, 2 words diverged in a wood, and I took the one less traveled by, and that has made all the difference. I think this body takes the road less traveled by. Our founders intended for us to defend freedom, to defend liberty, and frankly, we relentlessly sacrifice them for the other road of security. So I urge your diligent consideration of my amendment in the nature of a substitute, recognizing how autonomous the Rules Committee is. I anticipate the outcome on that. But I would like your careful consideration of the Confess Your Transgressions Amendment, whether it's adopted by structure in here or we have a more open process and an opportunity to vote for it on the floor. I think it would substantially improve the bill and get to the heart of, is anybody actually ever going to be held accountable?
Thank you very much. Are there any questions of our 2 witnesses here? Dr. Burgess.
Mr. Chairman, I just have to offer my favorite Robert Frost quote is, home is where when you have to go there, they have to take you in. That's the way I feel about the Rules Committee. Yield back.
Any additional questions? Let me just say, I appreciate your concerns, and I think it's clear that there's been a bipartisan agreement that has been reached, one that I'm not happy with, but I will vote no on the bill when it comes to the floor, but I appreciate your concerns. No other questions. You're dismissed. Thank you very much. We appreciate it. And this closes the hearing on H.R. 6172. And before the chair recognizes the gentleman from Pennsylvania for motion, I want to yield to the gentleman from Oklahoma for whatever he wants to add.
Thank you very much, Mr. Chairman. I just asked unanimous consent to place in the record, this is a letter that our leader, Mr. McCarthy, sent jointly to Majority Leader and yourself as chairman of this committee, which outlines our concerns about the process under which we're proceeding that I made reference to in my opening statement.
Without objection.
Thank you very much, Mr. Chairman.
All right, at this time, the chair recognizes will entertain a motion from the distinguished gentlewoman from Pennsylvania.
Mr. Chairman, I move the committee grant SJ Res 68 to direct the removal of the United States Armed Forces from hostilities against the Islamic Republic of Iran that have not been authorized by Congress, a closed rule. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking member, minority member of the Committee on Foreign Affairs. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule waives all points of order against provisions in the joint resolution. The rule provides 1 motion to commit. The rule also provides for consideration of the Senate amendment to H.R. 2486. The rule makes in order a motion offered by the chair of the Committee on the Judiciary or his designee that the House concur in the Senate amendment with 2 House amendments. Amendment number 1, consisting of the text of Rules Committee Print 116-52, the No Ban Act, and amendment number 2, consisting of the text of Rules Committee Print 116-53, the Access to Counsel Act. The rule provides 1 hour of debate on each House amendment, equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the motion and provides that the Senate amendment and the motion shall be considered as read. The rule provides that the question of adoption shall be divided between the two House amendments and that the two portions of the divided question shall be considered in the order specified by the chair. The rule provides that if only one amendment is adopted, that amendment shall be engrossed as an amendment in the nature of a substitute to the Senate amendment to H.R. 2486. The rule further provides for consideration of H.R. 6172, the USA Freedom Reauthorization Act of 2020, under a closed rule. The rule provides 1 hour of general debate equally divided among and controlled by the chair and ranking minority member of the Committee on the Judiciary and the chair and ranking minority member of the Permanent Select Committee on Intelligence. The rule waives all points of order against consideration of the bill. The rule provides that the amendment printed in the Rules Committee report shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Section 7 of the rule provides that on any legislative day during the period from March 13, 2020 through March 22, 2020, the journal of the proceedings of the previous day shall be considered as approved, and the chair may at any time declare the House adjourned to meet at a date and time to be announced by the chair in declaring the adjournment. The rule provides that the Speaker may appoint members to perform the duties of the chair for the duration of the period addressed by Section 7. The rule provides that each day during the period addressed by Section 7 shall not constitute a legislative day for the purposes of Clause 7 of Rule 15. The rule provides that it shall be in order at any time through the calendar day of March 22, 2020, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15, and that the Speaker or her designee shall consult with the minority leader or his designee on the designation of any matter for consideration pursuant to this section. Finally, the rule waives the requirement of Clause 6A of Rule 13 for a two-thirds vote to consider a report from the Committee on Rules on the same day it is presented to the House with respect to any resolution reported through the legislative day of March 23, 2020.
You have heard the motion from the gentleman from Pennsylvania. Are there any amendment or discussion? Mr. Cole.
Thank you very much, Mr. Chairman. We didn't get to this in debate, but I have an amendment to move the committee make an order amendment number 1 to SJR 68. And this is a little bit facetious, but the amendment adds the United Kingdom, France, and Germany to the list of countries against whom the United States must not commit hostilities. And let me tell you why I'm doing this. I would have no objection to a general statement that we should not be able to go to war against any country without a congressional declaration. I think we all would agree with that. The singling out of Iran concerns me because the implication is that that's what the president somehow wants to do. And quite frankly, he's emphatically stated he does not want to do that. Secretary Pompeo's emphatically stated. Interesting, right now, we're literally withdrawing troops that were placed in the region. They're beginning to be recalled home. But I just point out for the record that, if you look and see what the president said during his campaign, and many of us agreed with him, that he was going to withdraw from the Iranian nuclear deal. And frankly, I point out the majority of both houses actually opposed the Iranian nuclear deal. And yet the Obama administration went ahead and did it anyway. So it's not unusual you would withdraw from an agreement. Iran's action to that have been a series of provocations aimed at the United States. And we can go through them. It's literally, first we're going to shoot at ships in the Gulf. Did the president attack Iran? No, he did not. He urged other countries to send additional naval elements from their fleet and be in a flotilla against it. Then we have an incident where an American drone in international waters is shot down. The Iranians say it was in their airspace. Pentagon recommends an attack. The president says, no American lives were lost. I don't want to do that. Pull back, and got a fair amount of criticism for it. Then we have an attack on Iranian oil facilities. The president take out the missiles in Iran that did that? No. He sent additional defensive capability to Iran. Then we have a series of attacks on American forces that are stationed in Iraq and effectively tacitly allied with the Iranians in our common struggle against ISIS. And they start getting shelled by Shia militias that allied with Iran. Did the president attack Iran? No, he did not. He went after those Shia militias, took out some of their facilities, killed quite a few of their folks in Iraq. Finally, we have an incident where an attack results in the death of an American contractor and the injury of 4 soldiers, shortly followed by an attack by the same Shia militias that are sort of Iranian cat's paws on the American embassy. And the president says enough's enough. He didn't attack Iran, though. He took out an Iranian general in Iraq who was a designated terrorist and who, frankly, was violating a UN resolution by being outside the country at all. So I just say that to make the record. There's no need to go after the president to suggest through this legislation, which I think is the intention, that he wants to go the war with Iran. Actually, in this area, he's shown remarkable restraint, and he's going to get, he's already getting a lot of credit or a lot of criticism for some of his other actions in the Middle East. So if we're going to start listing countries not to go to war with, we might as well include the English. We've been at war with them twice. We might as well include the French. We were in an unofficial war at sea against them, and we fought the Germans twice in this century. So, you know, and I guess we could come up with another long list, but this is, in my view, the underlying legislation here is frivolous, and obviously we would much prefer it come, if you're going to bring up the bill, and let's have a chance to do a recommit on this thing. But that's not imply that the President of the United States somehow wants to go with Iran when every piece of evidence we have suggests precisely the opposite, and when he has shown restraint over and over and over again in dealing with Iranian provocations.
I thank the gentleman for his comments, and again, this is, we had a hearing in which some of these issues were brought up in more general terms, and I think we hopefully will continue to discuss ways to hold presidents accountable and to make sure that we're not cut out of a process if a president decides to go to war. But as the gentleman knows, this was a bill that was passed in the United States Senate, and it was passed in a bipartisan way. I think 8 Republicans voted for it, and I don't think their intention is to embarrass the president. I think it's just a legitimate concern that we need to restate what we all believe, and that is that, you know, presidents should not go to war unless explicitly authorized by Congress. But yeah,
and I would have no objection if we did just that.
Right. But anyway, the Senate passed this, and we're bringing it up, and if we change it, it goes back to the Senate. If we vote up or down on it, as it was passed by the Senate, it will go, and it passes, it goes directly to the president. So I would urge a no vote on this, although I appreciate where my friend is coming from. So vote is now on the, Dr. Burgess.
I just want to associate myself in the strongest possible way with the comments of Ranking Member Cole. I think he said it exactly right, and I think it needed to be said, so I'm grateful that he did it.
Again, the vote is on the Cole Amendment. All those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it. All right. Are there further amendments? Mr. Cole.
Thank you very much, Mr. Chairman, and I appreciate your consideration on the time and your comments. I have an amendment. As you know, we stated very strongly how we feel about the process that the majority is moving forward here. So I move that the committee strike the sections providing for consideration of the text of Rules Committee Print 116-52 and Rules Committee Print 11653 and amend the rule to provide for separate consideration of H.R. 2214 and H.R. 5581 as reported from the Committee on the Judiciary, both under an open rule. That's the way this legislation should be coming here. And frankly, you know, this effort to sort of deal us out, no amendments, no ability to recommit, will backfire. I mean, we're going to see a little bit tonight because we're going to have a lot of amendments tonight. We wouldn't normally do that. Just give us an opportunity on the floor within the rules and the traditions of the House to actually make our case. And that's not what's happening here. And so, you know, if our roles were reversed, I suspect you would feel just as strongly about this as I do, Mr. Chairman.
You heard the gentleman's amendment. Any comments or debate? If not, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
This one I would ask.
Clerk will call, roll call has been requested. Clerk will call the roll.
Mr. Hastings. Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Askin. Mr. Askin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman.
Clerk
no.
report the total.
4 yeas, 7 nays.
Members not agreed to. Further amendments. Mr. Cole.
Thank you, Mr. Chairman. In my never-ending effort to find common ground, I'm going to offer a little bit of a compromise here. And that is that we, again, strike the provisions providing for consideration of the text and the rules, and amend the rule to provide for separate consideration of H.R. 2214 and 5581 as reported, but under a closed rule as opposed to an open rule. So this would still preserve us the right to offer a motion to recommit, would protect the underlying legislation from any other amendment that might be a problem, but again, would not violate our rights as the minority.
Heard the gentleman's amendment? Yes, the gentleman from Georgia.
We're going to hear a lot about no motions to recommit, and the ranking member spoke to it in his opening statement. I've been on this committee for 10 years. I staffed it for 10 more. I can't ever recall a minority member saying, listen, if you have to close the process down, close the process down. If you have to shut our ideas out in their entirety again, then shut us down again, but at least give us that time-honored tradition of motion to recommit. It is almost unthinkable that the ranking member could have been so beaten down by the closed process that he's the one offering the closed rule. But I would just remind my friends on the other side of the aisle to separate this consideration and to provide a completely closed rule with nothing but a motion to recommit would be exactly the same language you voted for time after time after time all year long and the year before that. There's nothing nefarious about having an extra hour of debate on the floor so that you talk about so that you're able to consider these things separately. And I just don't want, again, because we've been so shut out, there are going to be so many amendments tonight. It's the first time in 20 years I've seen this, and I think it speaks to the unprecedented nature of the silencing of the minority, which, again, Mr. Chairman, runs completely counter to every other way that you've run this committee, which has been to open it up and to provide more opportunities for conversation.
Without belaboring the point, I appreciate the gentleman's comments, but I would remind him that we're using a perfectly legitimate process, a process that was used by Republicans numerous times during their majority, including 15 times during the past 2 Republican-led Congresses, to send important bills over to the Senate for their expedited consideration. I'm happy to provide the gentleman the listing here to refresh his memory.
Well, the gentleman need not refresh my memory, because he mentions that every time he does this process, and it hurts me a little bit more each time that you do.
I don't mean to hurt the gentleman.
Not because you point out my hypocrisy, but because you turn to exactly the kind of manipulation of the process and the facts that I think brings us here. It's true, and I expect the majority to use this process to move important pieces of legislation to the Senate. I don't expect this majority to use this process for the sole purpose of shutting down debate. And I would encourage the gentleman to go back and look at those items that he has listed from Republican-led Congresses. He will not find an example of our majority leader saying, guess what, I've come up with a great idea to completely shut down the minority, and let's use it in this way. That never, ever, ever happened. And so in the spirit of, again, we tend to find disagreement where we had agreement. I agree with you. We absolutely use that. I would argue that we used it in a collaborative, bipartisan way to move things that the institution supported. Never used it for the sole purpose of shutting down the minority, and that is, in fact, the reason it was used just a month ago, and the reason it's being used again today. I yield back.
You heard the gentleman's amendment. The vote is now on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Roll call, Mr. Chairman.
Clerk will call the roll.
Mr. Hastings. Mrs. Torres. No. Mrs. Torres, no. Mr. Perlmutter. No. Mr. Perlmutter, no. Mr. Askin. No. Mr. Askin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman,
Clerk, report the total.
4 yeas.
Amendment is not agreed to. Further amendment, Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment to the rule. Again, looking for a compromise. Maybe we can do one out of two. I move the committee provide an open rule for Senate Amendment H.R. 2486. Again, as yet another closed rule with no call for amendments. The Democratic majority is going to insist on silencing the Republican minority with regard to a motion to recommit. Then you should at least afford an opportunity for all members to offer amendments. An important piece of legislation, an area of considerable controversy. I think members on both sides would enjoy the opportunity to participate.
Heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Mr. Chairman, I'll ask for a roll call.
Clerk will call the roll.
Mr. Hastings. Mrs. Torres. No. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Askin. Mr. Askin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments, Mr. Cole.
Mr. Chairman, thank you very much. I have an amendment to the rule. I move that the committee provide for one motion to recommit with or without instructions. The Rules Committee print 116-52 and Rules Committee print 11653 and make the necessary changes in the rule. If Democratic members are unwilling to consider legislation as reported and would instead prefer to consider Rules Committee prints with the necessary modifications, this amendment would still allow the committee Republicans to offer a motion to recommit. And while we understand a motion to recommit is not in order on messages between the houses, this process is far from a regular order. And to quote my good friend, Mr. Burgess from Texas, we are the powerful Rules Committee. And we have the ability to make the exception. So all this amendment does is allow the minority to offer their motions to recommit to House amendments while still allowing the legislation to go forward as planned.
Heard the gentleman's amendment. Any comments, questions? If none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings. Mrs. Torres. No. Mrs. Torres, no. Mr. Perlmutter. No. Mr. Perlmutter, no. Mr. Askin. No. Mr. Askin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman.
Clerk,
no.
report the total.
4 yeas, 7
Amendment
nays.
is not agreed to. Further amendments, Mr. Cole.
Thank you very much, Mr. Chairman. I have an amendment to the rule. I move that the committee provide for one motion to recommit with or without instructions the House amendment to Senate Amendment H.R. 2486 and make the necessary changes in the rule. Again, this just applies to a single piece of legislation. This simple amendment would allow the entire legislative package to continue to the floor under the current rule, but with a single motion to recommit before final passage. I know it's not your intention to completely shut out the minority in this process, Mr. Chairman. That's not the way you've ever operated, and you've often talked about the need to open up the process. However, with a closed rule, no call for amendments, and a vehicle that prevents a motion to recommit, the minority party is completely shut out of the debate. By simply providing for debate time on this package, the Democratic majority fails to deliver on the adage that the U.S. Congress is the greatest deliberative body on earth. This is not good for the institution, and this is going to cause real problems. And I think my friend knows that. It's going to poison the well. I'd be happy to loan you our whip to teach your guys how to vote against MTRs if that's the problem here. But you shouldn't deal with your problem by shutting us down. You got great members here that vote with you in lockstep on these important issues, Mr. Chairman. surely other members of the Democratic caucus can vote without being afraid of an MTR, because if they are, they cut out our right to participate in the legislation. That's not right. That's not fair. And it'll meet fierce resistance over and over and over again. So we just want to make that point crystal clear. If we have to be the 300 Spartans, you know, we'll die here, but we'll be back on the floor. And I think you'll see the resentment at this kind of tactic expressed and shared by every member of the Republican conference. So with that, I yield back and move my amendment, Mr. Chairman.
You heard the gentleman's amendment. The voters on the Cole amendment, all those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
Roll
Clerk
call,
will call the
please.
roll.
Mr. Hastings, Mrs. Torres, Mrs. Torres, no. Mr. Perlmutter? Mr. Perlmutter, no. Mr. Raskin? Mr. Raskin, no. Ms. Scanlon? Ms. Scanlon, no. Mr. Morelli? Mr. Morelli, no. Ms. Shalala? Ms. Shalala, no. Mr. DeSaulnier? Mr. Cole?
Aye.
Mr. Cole, aye. Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mrs. Lesko? Mrs. Lesko, aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments. Mr. Woodall.
Chairman, I have an amendment to the rule to strike the text of Title II from Rules Committee Print 1652, and in its place insert the text of H.R. 5133 as reported from the Committee on Judiciary. You heard me ask the chairman about that while he was here. Again, I'm frustrated by the closed rule, frustrated by no motions to recommit, but that is a power the majority has. The majority also has the power to push forward our bipartisan consensus bills here. Judiciary Committee does very little in a unanimous way. That is the way they brought H.R. 5133 out of committee, and for reasons that were not explained by the Judiciary Committee, have not been explained here in this forum, we're just throwing out our work product in favor of the Senate work products. We've got senators on record saying the House work product is better. I've got senators who are willing to throw out their work product in favor of ours. There's nobody on the House side that says the Senate work product is better, and yet we're taking that work product up. The chairman said, hey, I believe this is going to be a faster process to conclusion. I don't know why he believes that. We're changing the text. The process is still a lengthy one, but if we cannot stand up for minority rights in this institution, perhaps we can stand up for our shared collective wisdom in this institution. The Judiciary Committee worked this through the entire committee process, passed it in a completely bipartisan way, and we could further not just Article 1, but our half of Article 1 by making the House language our pharmaceutical language in this text.
You heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Woodall amendment, all those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
That was very close, Mr. Chairman. Can I get a roll call, roll call vote?
Clerk will call the roll.
Mr. Hastings, Mrs. Torres. No. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. No. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall.
Aye.
Mr. Woodall, aye. Mr. Burgess.
Aye.
Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman.
Clerk report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments. Mr. Woodall.
Thank you, Mr. Chairman. I want to speak up on behalf of my Democratic colleagues, both the Vice Chairwoman of the Judiciary Committee, Ms. Scanlon, and rank and file member of the Judiciary Committee, Mr. Raskin, were both part of the team that supported that in a bipartisan way coming out of Judiciary. The motion, the amendment I'd make to the rule is to add a section to the rule that provides it shall be in order at any time through March 12th for the Speaker to entertain motions to suspend the rule and bring up this bipartisan bill, H.R. 5133, from the Judiciary Committee. Again, I dispute the Judiciary Chairman's conclusion that the fastest way to get prescription drug relief for the American people is to move the Senate language. But even if he is, not even if, I know he is sincere in that belief, it can do no harm for us to move the House language on which we have already agreed, on which senators say is the better language and the better solution for the American people, and have both of those products in the United States Senate so that the one that is most palatable to the Senate can move directly to the president's desk. Again, this is not the Woodall language. I have not gotten a chance to vote on this. This can be the Scanlon language. This can be the Raskin language. It puts our members in a terrible position to have voted yes on a collaborative bipartisan work product in committee, in one committee, and then have to come to this committee and vote no to disallow the House from having any opportunity to ever consider that language. I would not want that to happen in my Transportation Committee or my Budget Committee, and I would offer my colleagues the opportunity to prevent that from happening in this committee, as well as provide our constituents with the absolute best opportunity to get prescription drug relief as quickly as possible.
I heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Woodall amendment, all those in favor say aye.
Aye.
Opposed, no. No. Opinion chair, the noes have it.
Roll call, please.
Clerk will call the roll.
Mr. Hastings? Mrs. Torres? Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin? Mr. Raskin? No. Ms. Scanlon? Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Ms. Shalala? Ms. Shalala? No. Mr. Sonnier? Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall? Aye. Mr. Woodall? Aye. Mr. Burgess? Mr. Burgess? Aye. Mrs. Lesko? Aye. Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments, Mr. Woodall? Dr. Burgess?
Thank you, Mr. Chairman. I do have an amendment to the rule to add a Section 12 to the rule that would amend the text of the Rules Committee print 1116-52 as follows. On page 7, line 3, strike includes and insert does not include. And on page 7, line 6, strike regulation with quotation marks and insert regulation without quotation marks. The authorities and processes used for the Presidential Proclamation 9984, which was the suspension of entry as immigrants and non-immigrants of persons who pose a risk of transmitting the 2019 novel coronavirus, and other appropriate measures to address this risk, and Presidential Proclamation 9992, which you'll recall was the suspension of entry as immigrants and non-immigrants of certain additional persons who pose a risk of transmitting the 2019 novel coronavirus, that those two executive orders shall continue to apply to a communicable disease of public health significance as defined by Section 34(2)B of Title 42 Code of Federal Regulations. So this is a common sense, narrowly tailored amendment that would ensure that in the case of a communicable disease of public health significance, the current processes remain in place.
Thank
I urge
you.
adoption of that.
Heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Burgess amendment, all those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? Mrs. Torres? Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin? No. Mr. Raskin? No. Ms. Scanlon? No. Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Ms. Shalala? Ms. Shalala? No. Mr. Dusonier? Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall?
Aye.
Mr. Woodall? Aye. Mr. Burgess?
Aye.
Mr. Burgess? Aye. Mrs. Lesko? Aye. Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk report the total.
4 yeas.
Amendment is not agreed to. Further amendments, Dr.
I thought
Burgess.
it was closer than that. Yes, Mr. Chairman, I have an additional amendment to the rule to add, again, add a Section 12 to amend the text of the Rules Committee print 1116-52 to add at the end of Section 4B of the Rules Committee print, except that no such action shall cease if such action prevented the entry of aliens inadmissible on terrorism grounds. So, Mr. Chairman, this legislation before us would require that an agreement by the United States with another country to facilitate that country's sharing of known or suspected terrorist information or to share information about lost or stolen passports would have to cease on the date of the enactment of this act. I don't think that's a good idea, and I don't think that's a good way to protect the country, and I urge you to adopt my amendment.
Heard the gentleman's amendment. Any discussion? Hearing none, the voters on the Burgess amendment, all those in favor say aye.
Aye.
Opposed, no. No. Opinion of the chair, the noes have it.
And we should roll call.
Clerk will call the roll.
Mr. Hastings? Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Raskin? No. Mr. Raskin? No. Ms. Scanlon? No. Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Ms. Shalala? Ms. Shalala? No. Mr. Dusonier? Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall?
Aye.
Mr. Woodall? Aye. Mr. Burgess?
I'll vote yes on continuing to protect the United States of America.
Mr. Burgess? Aye. Mrs. Lesko? Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Dr. Burgess?
I've exhausted my.
Oh, you've, I didn't think that was possible. Ms. Lesko?
Thank you, Mr. Chairman. I have an amendment to the rule to add Section 12 that would amend the text of Rules Committee Print 116-53 by stating that Title III shall not take effect unless the Secretary of Homeland Security certifies in writing to the chairman and ranking member of the committees on the judiciary in the House of Representatives and the Senate that the Department of Homeland Security A, has sufficient resources to accommodate during the secondary inspection process the access to counsel and other assistance requirements contained in Section 302A of RCP 116-53, and B, determines that such requirements will not cause a substantial negative impact on the facilitation of lawful trade and travel into the United States.
You heard the gentlewoman's amendment. Any discussion? Hearing none, the vote is on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk, want a roll call? Clerk will call the roll.
Mr. Hastings? Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Askin? No. Mr. Askin? No. Ms. Scanlon? Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Ms. Shalala? Ms. Shalala? No. Mr. DeSaulnier? Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall? Aye. Mr. Woodall? Aye. Mr. Burgess? Aye. Mr. Burgess? Aye. Mrs. Lesko? Aye. Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk will report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments. Ms.
Mr.
Lesko?
Thank you, Mr. Chairman. I have an amendment to the rule to add Section 12 that would amend the text of Rules Committee Print 116-53. On page 5, after line 18, insert the following: except that such term does not include a person or organization that the examining immigration officer has reasonable suspicion to believe is involved in a criminal conspiracy with the covered individual.
You heard the gentlewoman's amendment. Any discussion?
Mr. Chairman?
Mr. Woodall?
This is one of those things that might absolutely come up in a motion to recommit. The gentlelady's amendment says, listen, I understand you want to open up representation, but you certainly don't want to open it up to folks who are involved in criminal conspiracies. This is not a divisive thing. This is something that we all would agree on. It makes the representation language stronger. If we had an opportunity to offer these amendments on the floor in an open rule or even a structured rule, wouldn't have to have them in a motion to recommit. This committee has an opportunity to include things that we know good and well are going to pass on the floor of the House by a giant majority, as the Lesko amendment would if it were to be heard. If we were to pass that ourselves here, we would prevent any sort of embarrassment that the majority feels about having motions to recommit pass, and we would also strengthen the language in ways that every single member of this panel and the members of the House would support, and I hope we will take advantage of that opportunity.
The vote is now on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings? Mrs. Torres? No. Mrs. Torres? No. Mr. Perlmutter? No. Mr. Perlmutter? No. Mr. Askin? No. Mr. Askin? No. Ms. Scanlon? Ms. Scanlon? No. Mr. Morelli? Mr. Morelli? No. Ms. Shalala? Ms. Shalala? No. Mr. DeSaulnier? Mr. Cole? Aye. Mr. Cole? Aye. Mr. Woodall? Aye. Mr. Woodall? Aye. Mr. Burgess? Mr. Burgess? Aye. Mrs. Lesko? Mrs. Lesko? Aye. Mr. Chairman?
No.
Mr. Chairman? No.
Clerk will report the total.
4 yeas, 7 nays.
Amendment is not agreed to. Further amendments, Ms. Lesko? Are there any other amendments? Hearing none, the question is now on the motion offered by the gentleman from Pennsylvania. All those in favor will say aye. Aye. Opposed, no. Opinion of the chair, the ayes have it. Okay, the clerk will call the roll.
Mr. Hastings? Mrs. Torres? Aye. Mrs. Torres? Aye. Mr. Perlmutter? Mr. Perlmutter? Aye. Mr. Askin? Mr. Askin? Aye. Ms. Scanlon? Ms. Scanlon? Aye. Mr. Morelli? Mr. Morelli? Aye. Ms. Shalala? Ms. Shalala? Aye. Mr. DeSaulnier? Mr. Cole? No. Mr. Cole? No. Mr. Woodall? No. Mr. Woodall? No. Mr. Burgess?
Yes.
Mr. Burgess? No. Mrs. Lesko? Mrs. Lesko, no. Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk, report the total.
7 yeas, 4 nays.
The motion is agreed to, and I will carry it for the Democrats. Ms. Lesko for the, Ms. Lesko will carry for the Republicans. Thank you very much, everybody. I appreciate it. Without objection, the committee is adjourned.